We are all women in the panel.
So we started.
Is this?
What?
Is it a quake? Hmm? I thought it was a quake. You know.
So they will give you a sign.
I'm not sure. Well, good afternoon, everyone, both to those of you who are joining us here in the room and those of you joining us online. Welcome to this session on addressing international crimes enabled by cyber operations. I'm Harriet Moynihan. I'm Head of Accountability in International Law at the Oxford Institute of Technology and Justice at the Blavatnik School of Government, University of Oxford. I'm also an Associate Fellow in the International Law Programme at Chatham House, and I'm delighted to be moderating this session. I'm also going to be joined online by Chelsea Smethurst of Microsoft, who's going to be helping with online moderation questions once we get into the Q&A. Today, we're going to look at how international criminal law within both national and international judicial settings can help to strengthen global cybersecurity and address core international crimes which are committed through cyber means. And of course, by international crimes, we mean war crimes, genocide, aggression, and crimes against humanity. And this session is going to highlight the forthcoming policy of the International Criminal Court on international crimes committed by cyber means. And that's obviously a significant milestone in investigating and prosecuting such crimes at the international level. This session is being hosted jointly by the International Criminal Court and by Microsoft, and I'm delighted to say that both are represented here today. And in this panel, we're going to have the opportunity to explore some of the legal, operational, and technical challenges in this area by hearing from a range of experts, from policymakers to private sector to civil society and the special advisor to the International Criminal Court on cyber-enabled crimes. And I should add that at Chatham House, where I've been working, we're conducting a research project on this very issue, which seeks to complement the work of the International Criminal Court. And we're going to be publishing a research paper that dives into some of the broader legal and practical issues around this area. And that paper will be published in January. Excuse the shameless plug. Today, our panelists are going to look at the evolving cyber threat landscape, challenges in the collection and attribution of evidence, the need for stronger multi-stakeholder cooperation in this area, and ways to strengthen accountability generally. And the way that we're going to do this is we're going to have a moderated panel discussion, and then we're going to open it up to Q&A, both from you here in the audience and those of you joining us online. But before that, let me introduce our speakers. We're joined online by two speakers. First of all, Professor Marko Milanovic, who amongst many other roles is the special advisor to the International Criminal Court, specifically to the Office of the Prosecutor on cyber-enabled crimes. Welcome, Marko. Also joining us online, we have Michael Karimian, who's Director of Digital Diplomacy at Microsoft. And here in the room, the stellar panel continues. We have Kati Reitzek, who's a prosecutor at the State Prosecutor's Office of the Republic of Estonia. We have Chantal Joris, who's Senior Legal Officer at Article 19. And last but not least, we have Katitza Rodriguez, Policy Director for Global Privacy at the Electronic Frontier Foundation. I'd like to start the conversation by turning to Marco. Marco, could you set the scene for us a bit by telling us a bit more about the Office of the Prosecutor's proposed policy in this area? How does it relate to the various initiatives that are going on worldwide in relation to cybercrimes? And what does it mean for the work of the International Criminal Court?
Thank you so much, Carrot, and allow me to welcome everybody, both online and offline, also on behalf of the Office of the Prosecutor of the ICC, to this event that we have jointly organized together with Microsoft. And thank you so much, Harriet, for moderating the panel, and to everyone for participating in it. So the basic message is simple. The Office of the Prosecutor launched this effort to formulate a policy document which will be used both for its internal purposes, but also for communicating with the public, which does several things. It explains how the Rome Statute of the International Criminal Court can be applied to the commission or facilitation of international crimes by cyber means. That's the first thing it does. It also explains how, other than the core international crimes, also the offenses against the administration of justice, which interfere with the working of the court as such, can also be committed and facilitated by cyber means. And then it goes on into various practical questions about the investigation, prosecution of these crimes, about the cooperation that the office needs to have with national authorities, and the capacities that the office needs to build to essentially be able to investigate these offenses properly. So that is the point of this policy. The policy has now finished the public consultation phase. We have received many comments from states, from civil society, including organizations represented at this panel, from academics, from various other stakeholders, which we will take on board. And the policy will then be revised and adopted by the Office of the Prosecutor and formally promulgated at the Assembly of States Parties later this year. So that is the core idea of this policy. And the message that the Office of the Prosecutor essentially wants to send is that it is ready, it is prepared to prosecute those who use these technologies to commit international crimes. Here, it is really important to emphasize, as Harriet did in her introduction, that we're not talking here about normal, ordinary cybercrime, like hacking, unauthorized access to a computer system, fraud, the dissemination of imagery of child sexual abuse, and so on. What we're here talking about is genocide, war crimes, crimes against humanity, aggression, and all of these crimes, including offenses against the administration of justice, can be committed by cyber means. AI, for example, can be used to facilitate attacks against civilians or the civilian population during an armed conflict, which is a war crime. Online technologies can be used to disseminate humiliating imagery of prisoners of war, which can also be a war crime depending on the intensity of the suffering that these individuals are exposed to. Attacks against critical infrastructure, against airports, against air traffic control can qualify, for example, as murder, as a crime against humanity. Direct and public incitement to genocide can very easily be committed by social media, and so on. So that's the core thing that the policy does. It really explains how cyber tools, including AI, can be used to commit these crimes. It also emphasizes the facilitation aspect. So many of these crimes can be committed, and most of them will be committed by traditional kinetic means, but cyber will be used to facilitate them. Everything from, obtaining targets to conducting monetary transactions using cryptocurrency, for example, in a way that facilitates the commission of these crimes. And the office is, again, it is ready to prosecute these crimes, and that is the key signal that it wishes to send through this policy.
Thanks, Marco. And it's encouraging to hear there's been strong feedback to the consultation. It's also great to hear that the policy will be out by the end of this year. So we're really looking forward to seeing that. And I think it's also encouraging to hear that international law, in this case international criminal law, is capable of applying to new technologies, that it's resilient and flexible enough to be able to meet the demands of these technologies that are evolving incredibly fast. And so, as you say, Marco, there's a lesson there that the individual perpetrators can be caught by this, whether they be state actors or non-state actors. And thank you for also making the important distinction between ordinary cybercrime and cyber-enabled international crimes, which I'm sure we'll hear more about. Kati, if I may turn to you now, I gather that your background is in a prosecution of organized crime, and now you're working on international crimes. And it would be interesting to hear the extent to which the issues and the challenges you come across are the same or different. And also, perhaps, if you can talk about what makes a successful investigation when you're looking at these cross-border type crimes.
Okay. Thank you, Harriet. Thank you, everyone, for gathering here today, in here and online. So, yeah, it's true. My main experience is more than 10 years combating organized crime. Just recently, I think maybe 4 or 3 years ago, I moved on to deal with cases concerned international law and international crimes. So, but there are so many similarities. If we are talking about core international crimes, there is very often a state actor at play. And if you are thinking about traditional organized crime, they often attempt to function as a state, within a state. It's like a parallel force. It maintains the hierarchy with clearly defined roles and assignments. Organized crime also collects and distributes finances as they see fit, provides financial assistance to those who need, and enforces its own system of punishment if someone were to break the rules. So if we think in these concepts, we see that there are actually very many similarities between a wannabe state, like an organized crime group, traditional one, or a really legal state. So, we then have to assess both the de jure and de facto powers of these persons acting within these systems and understand how these systems work kind of beneath the surface. Also, I have to say that in jurisdiction-wise in Estonia, there are also very many similarities. For example, core international crimes, Estonia exercises universal jurisdiction over them, as they are considered as crimes that every state, every civilized state, should be interested in prosecuting them. And the cross-border element is also something that is similar to those two. Because like organized crime, also crimes against humanity, they don't know any state borders, and they are not limited by it, but they might seek profit all over. So I think that what makes a successful investigation, both in organized crime and in crime against and in international crimes, is a judicial framework with your partners. You have to have a very good partnership with all the other state actors. And if we are talking about criminal investigations, I think you all agree that information and evidence sharing is of the essence. and you have to trust the partner that you share your information and evidence with, because otherwise you might be putting in danger your witnesses and your sources. So personal contacts that have always been very helpful in combating organized crime, which acts cross-border, and I think in international crimes as well. We have to build those personal connections, because sometimes time is of essence, especially if we are talking about cyber-enabled international crimes. Just tackling like a network, it needs to be very, very, very swift, and it is based on personal communication and personal sources. So it all comes down to willingness of the partners to investigate and get some good results. And of course, as we go on, all the evidence is being very, very heavily contested in courts. As you see already, if you are looking at the media, you see that if there is a news clip, already one of the parts of this clip might call it fake news, that this is doctored, this is not true. So in this digital area that we are living in, it's very difficult to know what is the truth, true truth, and what is doctored. And therefore, for investigators also, it presents a challenge to preserve and collect evidence in a way that it will be fully admissible later on in a court of law. As I mentioned, these personal connections that we use to tackle organized crime with, they are also being formed at international level concerning international crimes. For example, I would just point out the genocide network at the moment in Eurojust. And do not be fooled by the name. It's not only limited to genocide, but the members of this network actually share the experiences of investigating both war crimes and crimes against humanity as well. So I think I will stop here, and thank you.
Thank you, Kati, and thank you for highlighting the importance of partnership and trust and cooperation, and indeed giving examples of some of the forums that exist at the moment to try and promote that. And you mentioned the Genocide Network and the great work that they do. Michael, if I may turn now to you, and thank you for joining us online. The role of the private sector is very important in this space because, as we're hearing, by their very nature, cyber-enabled crimes are likely to involve infrastructure that will traditionally be owned by the private sector. It might be social media companies, it might be cloud services, it might be computer networks. And so it would be really interesting to hear from you about what role you see for the private sector in this space, perhaps particularly in relation to things like collecting evidence, because obviously some platforms will hold evidence. How do prosecutors go about getting that evidence? Well, they'll have to approach tech companies, or they'll have to go through states to do so. So any thoughts you have on, in general, but also in relation to evidence, would be really interesting to hear. Over to you.
Absolutely, and thank you, Harriet, not just for facilitating today's discussion, but also for the important work of yourself and colleagues at Chatham House in the research project that you're undertaking. And of course, thank you to Marco and colleagues at the Office of the Prosecutor for their essential work in developing the policy. It's been a real privilege to witness and support that work from the outset, and I'm very glad to be part of this discussion today. Evidence preservation and collection in cyber-enabled international crimes presents a number of technical, legal, and operational challenges. And I think Microsoft's experience could highlight several critical roles that the private sector can play in effectively addressing these challenges, roles that are explicitly recognized in the ICC OTP's forthcoming policy on cyber-enabled crimes, and also further expanded upon in Chatham House's important upcoming research. First, I think rapid identification and preservation of digital evidence are crucial, just as Kati was touching upon. Cyber-enabled crimes can often leave behind digital traces that are quite ephemeral and easily lost, deleted, or altered, and a number of technology companies have developed quite sophisticated technical capabilities for rapid detection, attribution, and preservation of digital evidence. For example, at Microsoft, our digital crimes unit, the DCU, routinely uses advanced threat intelligence, machine learning, and sophisticated analytics to identify and preserve relevant evidence from cyber operations swiftly and accurately. And these capabilities allow companies like Microsoft to secure time-sensitive digital evidence long before traditional law enforcement methods can respond. And that's a critical element which is highlighted in the OTP's draft policy as essential for successful prosecutions. Second, in terms of attribution, which is one of the most complex challenges in prosecuting cyber-enabled international crimes, the private sector brings unique technical capabilities. Accurate attribution requires the ability to track and correlate activity across different digital infrastructures and jurisdictions. And Microsoft's global telemetry and network visibility, which is detailed quite extensively in our annual digital defense report, enables quite granular tracking of cyber threat actors, including state-sponsored groups and sophisticated criminal networks. This capability aligns with Chatham House's research, which emphasizes the need for robust technical partnerships to enhance prosecutorial confidence and attribution. Third, the cross-border nature of cyber-enabled crimes demands unprecedented international cooperation, not only among law enforcement, but significantly with the private sector. And again, the OTP's draft policy explicitly underscores the importance of such cooperation networks, where you see emphasis on the value of private sector expertise in navigating jurisdictional complexities. And Microsoft, we have first-hand experience with such cooperation, including partnerships like our recent collaboration with Europol, where investigators are being directly embedded within the European Cybercrime Centre. Those types of partnerships really help to streamline international evidence sharing and overcome procedural hurdles, which again has been identified by Chatham House as a major bottleneck in prosecuting cyber-enabled crimes. Finally, in terms of ensuring evidence visibility in court, as we just touched upon, again, that requires private sector entities to follow quite rigorous standards in digital forensics and chain of custody management. At Microsoft, we have been proactively investing in building evidence handling capabilities compliant with international legal standards, again, recognizing the emphasis both the OTP and Chatham House place on meeting rigorous legal thresholds for evidence collection and admissibility. By sharing best practices and technical standards, I think companies can also help courts to build robust, credible cases against perpetrators. I guess I'll end by saying that the private sector's role seems to really extend far beyond just sort of passive cooperation, and instead it must really involve quite active partnership in evidence collection, attribution, international coordination, and ensuring procedural integrity. And Microsoft's experience seems to be relatively consistent with the OTP's forthcoming policy and Chatham House's comprehensive analysis, all of which I think demonstrates that strong public-private collaboration is advantageous, but also indispensable for effectively prosecuting cyber-enabled international crimes.
Thanks, Michael. And I think what comes out of your remarks there is the fact that the private sector are involved throughout the process, from the very beginning of an investigation right through to evidence being submitted to court in a trial. And it's also that word partnership coming out again. And thank you for the example you gave of the partnership with Europol. I'd like to turn now to another sector, another actor, civil society, and to you, Katitsa. Obviously, you work for the Electronic Frontier Foundation, and it would be really interesting to hear about what role you see for civil society here, how they can help, and perhaps maybe what the ICC should learn from the experience of civil society in this area.
Okay.
So thank you for the very kind invitation. We are actually really glad to see the prosecutor's draft policy on cyber-enabled crimes, especially because it explains how technology can be used to commit or facilitate crimes. Crucially, it sticks to the Rome Statute crimes rather than creating new type of crimes. And this is important because it helps guard against the very pitfall we have witnessed when a state has adopted overly broad cybercrime laws that have been used at the domestic level to undermine human rights. So we submit comments on the OTP policy consultation together with Derechos Digitales. And we come out with a few recommendations. From time, I will just share a few ones. One is, and I will focus on evidence in this case. First, evidence in this context must last. We are talking about 10, 20, 30 years. Video recorded today must remain courtroom ready, like for a long period of time, even 20 years from now. One mobile phone clip can expose a massacre and be published on YouTube. An algorithm can delete that proof forever. Second, the Rome Statute is crystal clear that every investigation must fulfill or respect international human rights law, meaning that the court must, the prosecutor and the authorities must gather digital proof and digital evidence under a framework of necessity, legality, proportionality, legitimate aim, and transparency, and of course, oversight mechanisms, which are embedded in international human rights law and standards. And third, overly broad surveillance and cybercrime status have jailed journalists and silent dissidents. The ICC should ensure not to rely on evidence gathered through such abuses surveillance powers and avoid risk legitimizing repression and unintentionally undermining its own cases. It's the time for everyone to work together to ensure justice can be delivered. And I think this is a good way of working holistically in these cases. And why does it matter? Because if the evidence disappears or it is tainted by abusive surveillance powers, the perpetrator walks free and the Rome Statute promise to victims is broken. And that's a serious thing. I'm thinking on the Guatemala National Police Archive. 18 million pages of paper records were discovered in a collapsed warehouse, later used in prosecution from disappearance and crimes against humanity. We had an interview with Patrick Ball, which is a data scientist analyst on the Human Rights Data Analysis Group, who told us that regime files have been central for documentary and data analytic evidence in trials of former heads of states in a couple of countries, where he identified patterns of repressions. In those cases, former dictators, police, and military leaders were convicted of war crimes, crimes against humanity, disappearance, and genocide. Without contemporaneous record, and Patrick told us, our work and his work would have been immensely harder. The digital age has not changed that lesson. It has merely shifted the evidence from dusty papers to bytes. And so they rely a lot on preservations and collaborations with the courts to preserve the evidence. So for lack of time, I will focus on just one topic, which is improper incentives to destroy evidence. But there are other topics that we like to talk about, territoriality or about joint investigations too. But on the improper incentives to destroy evidence, we are concerned that sometimes routine platforms functions are threatened with criminal or civil liability, and companies will and when this happens, companies try to over-comply with the law to avoid fines, steep fines. This creates an incentive for companies to mass delete information, content that can be used in litigation, that can be used, can serve as evidence and, in courts. The result is that the very material prosecutors need in a case is wiped and possibly permanently destroyed before any court can see it. So, and this is a case study. We have concerns of these global liability concerns and their own concerns about community standards. Platforms are being incentivized to delete conflict-related materials on a huge scale. And a paper that we wrote a few years back, where we document how YouTube used a new automatic extremism filter that was purging channels and videos of human rights researchers and journalists documenting Syrian conflicts. So our recommendation to the OTP is not only to caution about free expression, but also to ensure about the risk of destroying important evidence and that the risk from state compelling companies or companies voluntarily destroying evidence that can be used in courts. And we ask that that much good can come from collaboration, and and one of the things that could be done that the OTP should avoid is incentivizing these blanket takedowns orders, and instead should encourage platforms and states to honor public interest exceptions so that content with educational or documentation or newsworthy information remains online, even if it's graphic. So some of that is some of our concerns. NGOs, there are a lot of NGOs working on humanitarian response and in conflict documentations, whether contemporaneous or after the fact, may also hold the last, that we should collaborate with those NGOs because they may hold the evidence. And there are needs to ensure that, for instance, and that's the work of my colleague, of this friend, Patrick Ball, that it's document these cases and they use change of command and way of ensuring that the evidence don't get dated and that it still can serve in the court. And it can be done with a preservation order without relying on mass surveillance or abusive surveillance powers that will end up also impacting human rights. And I will stop here because of the 5 minutes.
Thank you so much. Thank you, Katice. And you've really underlined the importance of international human rights law, which is always good to hear, and the role of civil society and the importance of preserving evidence, which is difficult when these cases can take so long. Now, we have another voice here from civil society, as well as Chantal being a very impressive international lawyer. So I'd like to turn to you, Chantal. I know you work for Article 19, focusing on freedom of expression. So it would be interesting to hear if you have any thoughts on how that fits into this place. Also, if you have anything you want to pick up from Katice, and if there are potentially any things that the ICC needs to be bearing in mind when it's prosecuting these cases.
Yes, absolutely. Thanks, and thanks everyone for joining us at lunchtime or right after lunchtime. So I want to agree with Katice for sure. We think it's a very important initiative. Together with many other human rights organizations, we have documented extensively the way in which digital rights violations, freedom of expression violations, exacerbate harms for communities impacted by big conflict or prosecution or situations, crimes against humanity, occupation, and so on. So we have at Article 19 been calling systematically on accountability mechanisms. Also, for example, the International Court of Justice, as it assesses genocide cases, for example, in South Africa against Israel, to consider also the role of the human rights violations, free expression violations, digital rights violations, even if they may, in certain instances, directly amount to genocide or one of the other substantive crimes under the Rome Statute, but they certainly can play such an important contributing factor, be it in directly carrying out these more perhaps kinetic crimes, but also in contributing to a culture of impunity, in concealing evidence, and in potentially, prolonging the situation of conflict or prolonging the situation in which these mass atrocities can take place. So good initiative. Also, it will also be an important contribution. I mean, you mentioned there are so many discussions about how international law can apply. Does it have responses to these new technologies, evolving technologies? So it's also a very important contribution to that general discussion, I think. I think perhaps three main comments. So we have also recommended that the policy and of course the ICC focus perhaps a bit more on direct attacks. Marco mentioned critical infrastructure. That should include also, of course, ICT infrastructure. For example, there are there's such an increased use now of internet shutdowns through various means, kinetic means, non-kinetic means, that have extreme implications now in conflict zones and again, other zones impacted by atrocity crimes. And those should really also be considered more extensively. What impact does it have on civilians as they rely increasingly on digital technologies as well? Also, what impact, Katica touched upon it, what impacts do certain forms of online harms have on human rights defenders, on journalists, on specifically those communities that specifically in very restrictive information environments that we of course often see in those settings, they are key stakeholder, of course, for the evidence, to bring the evidence to the prosecutor. I also want to mention, we've talked about the role of private entities, technology companies. The policy does mention them as an important potential partner. It is a reality. At some, they often hold important evidence. They might be able to assist and cooperate in the prosecution, investigation of crimes. The reality is as well that very often those same tech companies are the ones that provide services to conflict parties, cloud computing services, surveillance technologies, AI capabilities that are also very much needed to perpetrate those exact crimes that the policy seeks to address. So I think that that sort of big challenge that we are facing, given that we have tech giants that are essentially used by every institution and every conflict actor at the same time, that needs to be spelled out better, I think, in the policy. And there needs to be a recognition that the ICC doesn't only rely on them, but also needs to put them on notice of legal risks that are involved with the proliferation of these services. How to avoid unintended consequences. Again, Katica touched upon it. The responses to cybersecurity threats, cyber crimes, very often fall short of international human rights standards, both in terms of the substantive offenses, but also in terms of how they are investigated. So I think it's very important that there is a clear distinction between the OTP being active in investigating, prosecuting crimes under the Rome Statute, but not extending, being too generous in extending cooperation with any domestic authorities that could go beyond what is really covered by the Rome Statute. And as a last point, I think that just means that it's very important that any human rights consequences are really carefully considered. That is through engagement, close engagement with civil society. We have this Article 21, paragraph 3 in the Rome Statute, of course, that says in terms of the substantive crimes, but also in terms of any prosecutions, human rights need to be considered. I think there is much to learn as well from human rights bodies. Taking the example of the idea of cyber torture, for example, has been quite extensively looked at under human rights standards. I think those are aspects that also the ICC can learn from and also avoid, we've talked about this yesterday, any fragmentation of how, for example, a torture concept in the cyber domain is understood as opposed to in the human rights aspect.
Thank you, Chantal. And thank you for mentioning the impact on civilians and journalists and human rights defenders. It's obviously quite easy to have these conversations in the abstract, but victims are and should be centered to this. You also mentioned conflicts of interest and thinking about how to manage those when partnerships are put together, which are very necessary. I'd like to have a bit of a more relaxed conversation with the panel now, just for a short time, before I open it up to questions. While I'm doing so, please be thinking of questions that you might like to ask, both those of you in the room and those of you online. I think there's a Zoom facility for raising questions, so do have them ready. Marco, if I may come back to you, it's clear that what we've heard is that there's all sorts of different ways in which cyber-enabled crimes can be carried out. For example, a commander using his phone to send a message to his troops to incite genocide. But at the other end of the spectrum, perhaps a massive cyber attack which uses very complex malware. We've also heard about mass surveillance. Obviously, the ICC's resources are finite. Do you have a sense of which kind of cases might be prioritized? And this is actually to all of the panel, but Marco, but perhaps start with you. Are there some types of cases that would particularly benefit from being prioritized here under the new policy?
I mean, it's a really interesting question, Harriet. And of course, it's one that I cannot answer by reference to anything going on right now, right? I mean, in the sense of what the office is actually investigating. I mean, I will say two things. So first of all, even today, even the most traditional kind of kinetic crime cases will involve digital evidence. So both, all of my predecessors talked about digital evidence as sort of being indispensable to modern investigations. That's true. So every kind of investigation that, for example, was dealt with by the tribunals for Yugoslavia or Rwanda a couple of decades ago would today involve analyzing people's phones, analyzing social media postings, analyzing various kinds of cyber operations, digital records, and so on. So in that sense, every single ICC case will have a huge digital aspect. Our policy, though, does not mainly deal with that. The whole question of digital evidence is so big that our policy only touches upon it. So again, our main focus is really on how can a person be held responsible for enabling an international crime by cyber means, or by committing an international crime by cyber means. And if the question is what's the best first case, my own sense would be it would actually be nice to start relatively small. So Michael talked about attribution being a huge issue in many cyber operations. It will be really difficult to prosecute a first case dealing with, super sophisticated state actors who are very well versed in hiding their tracks. You don't necessarily need to start off that way. A good way to start would be, for example, an Article 70 case, so a case about the administration of justice. Somebody hacks the court, which has actually happened a few years ago. Somebody falsifies evidence before the court uses AI to submit fake evidence to the court, intimidates witnesses or prosecutors or judges by using online means. Those are easier cases to deal with. And if it was up to me, a first digital or cyber case would be something fairly modest rather than something enormous. But I think that's a good way of testing various abilities and capabilities. But it really all depends on the facts. It really all depends on what the prosecutors have before them at any given time.
Thanks, Marco. Starting small sounds sensible in this area, which is pretty new and cutting edge, and establishing a good precedent would be good. Opening it up to the others. Katitza, what are your thoughts?
Well, I'm not a prosecutor, but I have an idea. I'm not an expert on the Roma Statute. I will defer that to the experts. But an idea that I have and that we have is discussing in my office is that investigate the use of cross-border malware campaigns that are targeted against ethnic groups and against diaspora community that have been used actually for transnational repression. But we are wondering to what extent to understand the scope and the impact of those campaigns against this ethnic group in order to see whether they may rise to the level of a Roma Statute crime or not. They may or may not, but there's so much we don't know about the scope and the scale and purpose of the use of malware in this context, so I would try to learn more of those details. And of course, we may find as the policy seems to suggest, that some of these are facets of larger campaigns and persecutions that have both online and offline campaigns. And just that's why, and just tying to the submission, when we were talking about the definition of cyber, we were saying that it can be used not only to directly harm people, but in order to identify targets from other attacks too. They could be used to locate targets for a physical attack, for physical persecution, but so we do envision and we hope that perhaps malware and other mechanisms would turn out to be part of this larger pattern again with online and offline elements. So it's not only also about the data, it's not just about the physical, but when it comes to, attacks against ethnic groups that have led to actually death, disappearance, and repression.
Yeah, thank you. And that actually relates to a question I had, which is, obviously, as I said, the ICC's resources are somewhat limited, and the draft policy makes clear that the prosecutor is only going to pursue the gravest cases. And in traditional cases, that usually does mean death and serious injury. But in the cyber-enabled crimes context, do we need to think about gravity more broadly or differently? Chantal, did you have any thoughts on that, or on anything that Katica said in this regard, which sort of some of the points that Katica herself was making?
I mean, perhaps I would agree with Marco. Starting small it is a good idea. I think also starting small could mean, again, for example, prosecuting a crime against humanity and explicitly recognizing, the chapeau elements, like what are indications of a widespread systemic attack on the civilian population that is needed for crime against humanity, and there, looking at questions around internet shutdowns, mass surveillance, and so on, or looking at a war crime around impeding humanitarian assistance, looking at has this happened also through attacks. And so it could also be another way to just more emphasize that role in the commission of more kinetic attacks. I think also when it comes to what you mentioned around the assessment of harm, assessment of gravity is obviously very, very complicated, as we have these more sort of kinetic, physical notions of harm. I think at least, I mean, there are so many, on the one hand, indirect consequences. Again, a shutdown might, kill someone because they can't communicate with the hospital, or even further down the line, there can be psychological consequences, so other types of harms. But I also think we should not completely forget any sort of broader societal impacts, economic impacts. They might not neatly fit under any of the crimes under the Rome Statute, but I do think they need to be considered as well, and the ICC should be cognizant of those broader effects of what a mass surveillance campaign can produce within a population, and consider those aspects as well. Yeah.
Thank you. Kati, as a prosecutor, I can't resist asking you, what would be your sort of first kind of case? What would you be thinking would be some of the, I suppose there's no such thing as an easy case, but perhaps one of the priority cases in this area? Do you have a sense for that?
Yeah, I think that at first, as a national prosecutor, what I would, if I were a national judge, I would really like the ICC to show us the way, by choosing whether a war crime or a crime against humanity, because these would give us kind of the ICC the more broader possibility to say the essence of this new terminology that is being used, like cyber-enabled, and how will it start to fit in ICC's work. And I also want to say that I think that national courts can look up to ICC as a kind of beacon leading the way, and being maybe encouraged by the ICC's very systematic approach to cyber-enabled international crimes. If we are talking, of course, preferably, I would not have any cases of war crimes or crimes against humanity. But in Estonia, you would have to take into account the very, very strict in absentia rules. So I think this is also, and it depends on, of course, of the state, of the rules. But for example, in Estonia, you cannot indict anyone unless you have pressed charges and the person has been present to see the charges and has had the possibility to personally get acquainted to the material of the criminal investigation. And then maybe later on, maybe in trial stage, if this person then leaves, then we can kind of carry on without him or her. But yeah, the rules in national courts are even sometimes a bit more stricter than in international courts, if we are talking about. So I would choose a case where I would have a suspect like present. So this is definitely something that I would choose. Also, a war crime and a crime against humanity, maybe war crime episode could be more individual. You don't have to have that many aspects in, it doesn't have to be very, very large scale. For example, if we're talking about genocide, I think that the burden of proof there is much more higher and much more difficult to obtain, for example, than if we're talking about war crimes or crimes against humanity. So definitely I agree with Marco that should be like smaller, start with small steps, but still significant enough to lead the way.
Yeah, thanks, Kati, for thinking about some of the sort of practical and procedural issues that come up in these cases. And you mentioned about having the suspect in the jurisdiction. Obviously, in the cyber context, often these operations are carried out remotely, certainly if we're thinking about a cyber attack. And that can be one of the problems, that the suspect is in a jurisdiction that refuses to extradite. So I can see why you'd like that as a starting point. Michael, I've been leaving you a long time. Thank you for being patient. But I had a question for you, which is for all the panel, but to you to start with, which is really to think about the ICC's policy more broadly. What are the wider benefits? Do we think there are wider benefits? Do you think states will embrace this? We have heard from Kati that this policy could lead the way, and I certainly think it is groundbreaking and significant. Do you see it as having impact beyond just the ICC?
So, in brief, the answer is yes, Harriet. Firstly, I'll just maybe turn to the other questions you were posing there to the panel. So in terms of prioritizing cases, absolutely a long-term view is essential. In an ideal world, once the policy has been released, we would see dozens of cases in front of the court, but of course, perhaps that's not so likely. Ultimately, it's up to the Office of the Prosecutor to decide which cases to prioritize, but one way to think about it would be cases that involve widespread harm to critical infrastructure, as Chantal mentioned, but also critical services such as healthcare, humanitarian organizations, or essential utilities. And those are sectors we already see being highly targeted by threat actors anyway. And there are two reasons for why I think it's beneficial to focus on such cases. One is that these attacks pose substantial risks to human life and well-being, even if their immediate physical harm might not seem as direct as traditional kinetic violence. And also prioritizing such cases sends a clear international signal about the unacceptable nature that such cyber operations pose when they endanger civilian populations. And again, just briefly, Harriet, on the question of gravity, of course, traditional definitions focus on physical violence and direct casualties, but of course, cyber-enabled crimes can lead to severe, widespread and prolonged disruptions of essential services, as well as significant economic damage and psychological impacts, again, as has already been mentioned. And so I do think we should consider how such assessments can incorporate not just immediate physical harm, but also the scale, scope, and duration of those indirect humanitarian consequences that cyber-enabled crimes can cause. That's something which perhaps we need to expand upon further. In terms of that question you mentioned there, Harriet, of wider benefits of the ICC's involvement, I am optimistic that states will embrace the ICC's initiative on cyber-enabled crimes, because these threats affect everyone, really. They transcend borders. However, there will undoubtedly be challenges and sensitivities around sovereignty and jurisdiction. But despite this, the ICC's involvement can significantly enhance the legitimacy of international efforts to hold cybercriminals accountable, and quite importantly, to set legal standards and precedents elsewhere. Additionally, I think the ICC's focus can stimulate more robust national action. So Estonia leads the way in its application of the principle of universal jurisdiction. We'd love to see more countries taking such action. Perhaps we will see that. But of course, other benefits we might see include fostering better cross-border cooperation and encouraging public-private partnerships, all of which I think would ultimately contribute to greater global cybersecurity and resilience.
Thank you, Michael. Thank you for addressing all of those points and thinking through a bit how this policy could have wider benefits. I'd like to hear from you as well. We start with you, perhaps, Katica, about the idea of the policy leading the way and having wider impact.
So, well, I agree with the prosecutor about a specific case that will lead the way, but I want to build upon the last speaker's comments. I think it's clear that every year that computer systems are used in various ways in committing like mass killings or all kind of crimes under the Rome Statute, and I think there will be many, many more cases as technology advances and the prosecutors and will start authorities start investigating those cases. But at some point, I think when I was reviewing the draft policy, the OTP mentions that military cyber attacks targeted against civilians, perhaps including civilian ICT systems, civilian data, and groups of civilians, could conceivably constitute war crimes even without causing tangible physical injury. And we think that this perspective is useful because of just how important ICT systems are in people's life, culture, family, livelihood. It's not just like a hobby, it's part of how communities and society organize themselves and talk to themselves. And it's also about organize themselves when there is like a bomb coming and we need to, leave the area. Maybe we need that mechanism of communication to be able to, go to a safe place, and being cut off of that is just like problematic. So cyber attacks against, communications infrastructure, but also against data or things that will not allow people to get health information or information that is crucial to get timing could be really problematic. And that may lead eventually to personal injury, but not directly, and I think that's equally important.
Thank you. Before we open it up, Kati, Chantal, I'd be interested in your thoughts on this sort of wider question. I mean, the question about whether states will be interested in this policy, whether they will be leading the way. There have actually been some states, I should say, that have prosecuted war crimes which involve cyber means. So, for example, fighters in Syria who have been filming pictures of dead bodies or maimed bodies and putting them online. They've been prosecuted in France and the Netherlands and I think Norway as well, actually. So it would be interesting to hear your thoughts on this as a state prosecutor.
Okay, thank you. As Katica very well pointed out, that our societies are changing, and the values that we kind of tend to take granted, like with all these information technology systems, they are totally different than, for example, 10 or 20 years ago. But if you think of the judiciary system in many countries, the people who are working in judiciary, they're, for example, judges. This is a position for life. So it means that we might have in the judiciary system very many people who are not they don't feel comfortable with dealing with this digital era that has dawned upon us, right? So more and more we have to rely on technical expertise as well. So I think that, and it's probably the same in every country, that there always will be people who are willing and wanting to learn and to develop their knowledge. And I think that we should be, and should help them and assist them. And of course, the private sector's assistance, the trainings, the investigators have to be trained. So from a very practical viewpoint, as you pointed out, yes, there are videos, and it's not that complicated to see whether it's authentic and what's the metadata behind this video or a photograph. But still, as they are going more complex and complex, and as you pointed out, these foreign actors, they might be cross-border, we will never see them. And we will have to tell and explain to the court how exactly a very, very sophisticated digital attack has been committed. It definitely needs high-level expertise from outside of the investigative authorities. And just on that point, I would like to point out that, for example, in Estonia, we have a cyber crimes unit in our central criminal police, right? But international crime is being investigated by the security service. These are two totally different authorities with totally different kind of, not background, but their data and their intelligence and their focus is on different things. Therefore, if we are talking about very successful investigations, we also have to see that siloing your data and information between investigative authorities is not an answer, but you have to also cooperate and exchange the knowledge that one or the other unit actually has in order to have a successful investigation.
Thank you. So joined up, not just cooperation between states, but even within a state. Yeah,
yes.
Very interesting. Yes. Thank you. And Chantal, over to you for any final thoughts on this.
Yeah, I think from the perspective of civil society, I think we can also for us, we can use the policy as well in our advocacy. We have plenty of conversations about the role of taking on conflicts, for example. We have one 2 days ago at IGF itself. So I think it just helps also sort of complete the picture from different angles. And also, Kati, you mentioned that it might also be leading the way in terms of the domestic authorities. And, the ICC has so many jurisdictional constraints, plus this element of gravity that you mentioned that makes it a fact that they will not be able to prosecute that many cases. So I think I find it also very interesting to think about, strategic litigations in front of domestic courts under universal jurisdiction provisions, and then we have the policy, showing that it is not something totally far-fetched, and it contains a lot of interesting examples that can be used to think about how we can push the needle further in this aspect.
Thank you so much. Well, we've got lots of food for thought there, and thank you to the panel for setting us up for the Q&A. So now is the chance, if you would like to raise a question. We have a microphone here. We already have one questioner. That's perfect. So feel free to form a queue if you'd like to raise a question. And also, for those of you joining us online, please do type in your questions to Zoom, and Chelsea, my online moderator, will help to get those to us. So if I could turn to the first questioner to say your question, please.
Yeah, Jori Bokovoi from the Finnish Green Party. Chantal mentioned about crimes against humanity or human rights violations in suppression of information networks. One thing that comes to mind is and this is the question more, I guess, to Marco, in which, I guess, capacity does this apply to also partial suppression of network, which you have seen, especially recently in the Southeast Asian territories, where internet shutdowns have been used to push users more to telecommunications in traditional way, which are more easy to surveil and break their privacy in that way. And I have a second question about, Katica was mentioning the removal of evidence by social media platforms. There are known cases of organized crime being perpetrated or conspired through gaming platforms as well, like the PlayStation Network or different other services, which a lot of them don't even record or monitor the voice chats, because it's much cheaper for them to either turn it off in the regions where they're forced to, or just leave it on and not deal with it at all, and basically wash their hands in the regions where they're not. What can be actually done about that?
Thank you very much for both questions. So The first question was about the suppression of networks and internet shutdowns and thinking about how the proposed policy might be relevant to that. And Marco, perhaps if I turn to you on that one initially.
Well, thank you. I mean, it's an excellent question. So I have to preface it, though, by doing this horrible lawyerly thing, which is to make some...
Marco, we've lost the sound. Not sure if you're muted. It's okay, your end, so it might be our end. Just give it a minute.
Testing.
You're back.
Yes,
perfect.
Yes.
Thank you.
Good. So the key point I want to make is that most internet shutdowns are human rights violations, right? In particular, they violate freedom of expression. To date, of the examples of various internet shutdowns that many states have done, it is really difficult to find an example of an internet shutdown that could be justified in human rights terms. So most internet shutdowns violate human rights in a relatively straightforward way. However, it is difficult to say, though, that every internet shutdown is a crime for which individuals accrue responsibility at the international level. For example, a crime against humanity. A crime against humanity is defined, for instance, as an act which takes place in the context of a widespread or systematic attack against the civilian population. Crimes against humanity include, for example, things such as murder or extermination. They could include persecution, which is a discriminatory denial of fundamental rights, and one could think of an extreme type of an internet shutdown that could qualify as, for example, persecution. But the vast majority of internet shutdowns will not be criminal in nature. So that is the sort of point I would make. Remember, our policy is not about human rights online. It is about international crimes committed by cyber means. And so only a smaller subset of human rights violations in the digital context will actually accrue criminal responsibility directly under international law. There might again be some shutdowns that could be justified. You saw, for example, how a few days ago, Iran shut down the internet on its territory in order to stop cyber attacks from Israel, right, in the context of an armed conflict. That is one of those rare situations where you could think of a justified shutdown. Maybe. Yeah, again, so the fact that most internet shutdowns violate human rights does not, however, translate to an international crime, is the point I would make.
Thanks, Marco. I'm very clearly explaining the distinction there. The other question was about the removal of evidence by social media, and the questioner mentioned in particular gaming platforms and the fact that they don't even monitor voice chats sometimes. So there's this problem with having evidence and retaining it. I don't know if any of you would like to either pick up on that question or the question about internet shutdowns. Of course, Katica, you'd mentioned this issue of internet shutdowns. So if you have any thoughts on that question.
I was mentioned more whether it rise or not to a Roma statute crime. And that was more my question from the prosecutor, because we are not like super experts on all the court cases that are under the Roma statute right now. Sure. So it was whether or not it could potentially rise. I didn't understand the question on evidence on platforms. What was the question?
I think it was about the fact you'd been talking about preservation of evidence, and that sometimes social media platforms have been accused of deleting evidence. Yeah. And that with gaming platforms, that might be a problem because sometimes they have even less sort of transparency around what they're doing, and they may not even be recording the evidence at all. So that might be I don't know if that's an issue you've come across.
We don't want retention. Like, retention is different than preservation. Preservation is linked to a specific crime. It's for a specific period. It's not mass surveillance. So I don't know if he is specifically concerned about, what we say in FF, if the data exists, it will be law enforcement who will access to that data. Some companies have certain policies that about how long they retain certain data. Now, when we ask preservation, is when there is like they don't have all the necessary information right now to probably as a court order on data, but they asked authorities to preserve it for a period of time for a specific investigation. The nuance in the Rome statute is that these crimes take 20, 30 years. It's not crimes that comes very fast. They take years to, changing governments and be able to prosecute someone, and how we preserve the evidence and how that will work, how we do a change of custody in a way that, for instance, civil society, who may be more up to date with where evidence and violations have happened, can learn from the traditional human rights NGOs who have been doing Rome Statute for years, documenting abuses, and trying to do it in the digital age with chain of custody and all the knowledge that we have about hash, metadata, and trying to have these standards. So whenever is the time to bring the case to justice, the evidence it can pass the test that the court settled for admissibility of evidence in the court. And that was my point, not to try to establish laws that will, and I don't know if that was his concern, that will record all chat or voice communications on all platforms, because that will be disproportional, and that will be against what the court is aimed to do, which is protect also human rights.
Yeah, thank you. Chantal, did you have any thoughts on this?
Yeah, I mean, I think there's also a lot of obvious discussions around the role of many social media platforms, larger, smaller, in how they moderate content, and they should have heightened human rights due diligence if their platform is used in conflict settings or in settings of where mass atrocities are likely. And of course, the task can be a challenging one. You might have inciting language that you don't want to have on the platform, but if the inciting language comes from someone very high up in the government, there is a clear public interest to understanding whether they incite violence. There is public interest content that can violate a policy that prohibits violent content. So that is even on the content moderation level itself, right? And there is also the fact that many conflicts or again atrocity situations happen in languages and in markets that are unfortunately not of big sort of strategic interest of the companies. So there's not a lot of resources invested to really understand and properly tackle these challenging tasks. And of course, there are sometimes also clear geopolitical alliances that also, or alignments that will also favor one side of the conflict over the other. And then that's even only on the content moderation level. And then, of course, even if moderation or removal might be justified, then there's a question around, how do you preserve that sort of evidence? What sort of mechanisms do you have in place with accountability mechanisms or certain vetted CSOs or international courts, so that those that evidence doesn't get lost. And again, we're often talking about extremely restrictive information environments where journalists are threatened, killed, have to go into exile, where the only evidence that you have really comes from those users that simply witness what's happening.
Thank you. And I suppose just one point that's come out of our Chatham House research is that some of the bigger companies have quite sophisticated systems for at least holding evidence and for providing that evidence to law enforcement, whereas some of the smaller companies, and you mentioned the gaming platforms, but there may be other smaller companies who are just not as set up for this. Their procedures aren't perhaps ready, and there may be a role for training and cooperation around those issues. We don't, as far as I'm aware, we don't have any questions online yet, so I'm going to throw it back to you, the in-person audience, and we have a question over to you.
Yeah, good afternoon, everyone. I'm Aaron Clements-Hunt. I work for the Heartland Initiative. Thank you, Harriet, and all the panelists for a really thought-provoking discussion so far. My question is to Michael. There seems to be a pretty clear tension between Microsoft's admirable work in partnership with the ICC and their now well-documented involvement or links to cyber-enabled crimes. I'm talking in particular about the fact that since the Hamas attack on Israel in October 2023, Microsoft has surged capacity and services to Israeli state entities, including the Ministry of Defense and the IDF. So my question, Michael, is Microsoft really in a position to lead private sector efforts to address international crimes enabled by cyber operations when the company itself can be credibly linked to those very crimes?
Thank you. So, Michael, I didn't go to you before on the questions we had earlier, so feel free to pick up on any of the ones we've had already, including the idea of companies cooperating on evidence. But that question was obviously about this question, I suppose, that came up earlier about the sort of potential for conflicts of interest, how tech companies approach those. As we've heard, tech companies are important in this space. Their cooperation is vital. But at the same time, it's important that conflicts of interest are managed. So if you could talk to that.
Thank you, Harriet. Glad to do so. Firstly, in terms of the question on internet shutdowns, I really appreciated Marco's articulation of the way in which the policy will likely relate to internet shutdowns. Just broadly, if anyone is interested on this topic, Access Now has done tremendous work in its coalition and campaign in shedding light on the impacts and widespread use of internet shutdowns. And that's available online at their Keep It On webpage. Definitely encourage colleagues and interested stakeholders to take a look at that. In terms of the earlier question as well on online gaming platforms, historically the issues we've seen there have more fit into the categories of child sex abuse material online, so CSAM, as well as terrorist and violent extremist content, TVEC. But that's not to say that actually we won't see connections to the crimes relevant to this policy, war crimes, crimes against humanity, and genocide in online game platforms, if we take a very long-term view as to how actors may engage in those platforms in the long term. As some stakeholders might know, UC Berkeley's Human Rights Center just submitted evidence to the OTP in relation to a case in Mali, evidence in Mali, which really demonstrates the use of multimedia and outrages upon personal dignity. And actually, it's possible to see how you would witness similar uses of multimedia in online gaming platforms too. And so this question of retention in such platforms is really critical. And so just as you touched upon, Harriet, how companies of different sizes can effectively retain such evidence, because, we should anticipate that their uses will evolve in years to come. In terms of that question just now from a colleague from the Heartland Institute, this is a really important topic, and I appreciate that it has been brought up. There has been a lot of information in the public domain about this, and Microsoft recently published a blog post in the past month or so, which is available online. And of course, I would encourage anyone interested to please take a moment to read that. The blog post seeks to provide insights to the work that Microsoft has been doing to better understand the issues. So, for example, we've hired an external third party to undertake an independent assessment to identify the extent to which the allegations that came out in the press in January and February were truthful. And as well, the company has been undertaking its own investigations in this space by engaging with Microsoft's subsidiary in Israel. And with that, it was found that actually there is no direct connection between the provision of Microsoft services and the conflict in Gaza. And there is work now underway to improve how human rights due diligence is applied in these contexts, building upon the company's long-standing human rights policies and practices. To the kind of question, Aaron, which you posed as well about kind of the conflict of interest and tensions here, and Harriet, you picked up upon this earlier. This also came up in the discussion so far. This is a challenge whereby these large platform companies provide products and services to a wide range of customers around the world, and those customers in turn can use products and services in harmful ways. This is a challenge that has existed across how companies apply the UN Guiding Principles on Business and Human Rights, an extent to which they can effectively conduct human rights due diligence, and where needed, have remedy and transparency in place. this is not unique to the issues that we're discussing here in the context of the ICC's, OTP's upcoming policy. But it does demonstrate, I think, not just the responsibility that companies have. Companies, of course, have a responsibility to respect domestic law. They also have a responsibility to respect international law, including international criminal law. And when Microsoft's human rights policy was last updated, which I believe was 2019, and the policy is available at microsoft.com/humanrights, intentionally, the Rome Statute was included in the list of human rights frameworks and individual conventions and frameworks which the company looks to when it seeks to uphold its corporate responsibility to respect human rights. And so that recognition is there, and this policy, I think, will go a long way to assisting technology companies, including Microsoft, among others, to be better at respecting international criminal law, as well as identifying the role that they can play in helping all actors address cyber-enabled crimes.
Thank you, Michael, and I recommend that blog post as well. We are also going to have another opportunity to go to in-person questions if there are any questions. I think there was one over there, so thank you. If you'd like to say where you come from before you say the question, thank you.
Of course. I also want to remind you that there are two more people who want to ask the questions.
Thank you.
Thank you so much for an excellent panel. My name is Vilde, and as a criminologist, I've spent a lot of time looking at traditional crime versus cybercrime and the differences between them. And obviously there are a lot of similarities, but in my opinion, cybercrime have so many unique elements to it that it's hard to sort of treat them the same way. So I would love to hear your thoughts on this when setting up a system to deal with cybercrime. Where do we, in which part can we use the tools that we already know, and where do we have to start from scratch? Thank you.
Thank you. And now, Kati, I'm going to go to you on that, but you're very welcome to touch on any of the things that we've heard in all the questions if you have thoughts. It's similar to the point in a way that we were talking about organised crime and cybercrime, but if in your experience you're seeing anything that's, some of the unique features that the questioner mentioned and how those can be addressed.
Well, thank you for the question. Yes, it might seem, and it definitely is, that investigating cybercrime, there are so many nuances that one must know in order to get the evidence from the private partners, in order to seize the evidence quickly, as I said, as it is very, very prone to being deleted. So this is the cooperation part, which in some ways is the same, but the investigators have been training, have had extensive training also on how to, for example, seize digital devices in order not to compromise the material that is in the digital devices. Also, we should not forget digital currency, because we have to, as organized crime and crime in itself, there is financial interests moving in these circles also, and in order for the crime not to pay, states also have an obligation to seize possible criminal assets, whether they are in a physical or crypto form also. And this needs a specific knowledge and training, and our investigators in cybercrime units are trained to do that. But in the end, sometimes it all comes down to the good old ways of collecting evidence. For example, you have to have, as these are all covered crimes, you don't necessarily have a victim, if we're talking just about cyber crimes, and who could point out the actor. You need intelligence. You need good old-fashioned intelligence, which is very difficult to get if these actors are not in your own country. And this, of course, then intelligence agencies and their partnerships are coming to role. If we are talking about organized crime, cyber-enabled international crime, I wanted to point out this aspect before, And also, when civil society was talking about communicating with victims and witnesses, actually, and collecting evidence themselves. In a matter of trust, it's also important not the partners only to trust each other, but the victims and witnesses to trust the law enforcement in order to turn to us. Because in many countries, it's not like that. In Estonia, we see that most people, we trust law enforcement and we don't kind of fear retaliation if we turn to the police, right? But it's not like that in many countries. So even if we have, for example, citizens of other countries who are on Estonian territory and could be valuable witnesses or victims of international crimes, it's also difficult to gain that trust because they're in a foreign country. They don't know what's going on. They don't know the traditions or the background. So this is also something we have to address as law enforcement representatives. Also, if we are talking that digital evidence might disappear, so can human evidence disappear, because judicial systems are very different of how we accept a person's testimony. For example, if we go to trial in Estonia, just this written paper, maybe in pre-trial phase, this means nothing. It's nothing unless I have to bring the person into court. They have to be cross-examined, and then it will be like good evidence. Otherwise, I will not be able to use this kind of pre-trial piece of paper testimony, maybe only if the person is dead. Or, yeah, maybe. That's about it. But this is our own national kind of specifics. Every national system has its own. So we have to think about preserving human evidence as well. Maybe because you are absolutely right. After 10, 20 years, 30 years, these crimes against, these international crimes, they don't have any statute of limitations.
Thank you. And interesting to hear some of the similarities as well as the differences and unique features. Now, we haven't got many minutes left, so we're going to have the two questions together. And if you could be brief, and the responses will be brief, then we can stick to time. Over to you.
Yes, thank you. My name is Christian Fazili. I'm a public prosecutor from the Democratic Republic of Congo. And thank you for the insightful presentation and discussion. So regarding the situation in the DRC, as you know, recently, our courthouse has been destroyed when the M23 took over the town. So I would like to know, how can prosecutors prove command responsibility via digital traces if our forensic labs in Goma and Bukavu are destroyed? Another one is, how can Article 28 of the Rome Statutes apply for foreign officials enabling cyber war crimes? If not, how do we close these impunity gaps? Thank you very much.
Thank you.
Hi, my name is Meredith. I'm with the Business and Human Rights Resource Center. Thank you for this fantastic panel. My question actually is for Marco about any updates to the draft policy. Chantal had pointed out that the language is very much in favor of corporate cooperation for getting what's needed in order to effectively implement the new policy, but is there a shift now that we can expect in relation to accountability, given, as you mentioned, that making sure that individuals are accountable for these crimes is the key ethos behind the document as such, including tech executives who may be involved in the execution of some of this, whether or not there's explicit instructions coming from a state? Thank you.
Thank you very much to both of you. Given time, we're going to have very quick responses. Marco, I think one of those questions was directed to you, but if you wanted to pick up on any of them, then please do, and just have 1 minute.
Sure. On superior responsibility, I would simply direct you to looking at the draft policy. The draft policy directly addresses questions of liability for modes of liability other than direct commission, and it includes a discussion of superior responsibility. So we do think that an individual can be responsible by those means, but via Article 28 of the statute, including for cyber-enabled crimes. I will not talk about specific situations, though. On the question of corporate actors and accountability, we have had very productive engagement with civil society organizations, in particular, those focused on business and human rights, and we took their comments on board, and you will see the exact formulations the policy will use when the final text comes out. But I can assure you that the policy does include language that acknowledges the potential criminal responsibility of corporate executives.
Thank you, Marco, and thank you for being brief. I'm sure that we all have further comments, but I'm very conscious of time. So I would just like to take this moment to do a bit of summing up before we close. I think we've heard that existing international criminal law is very much fit for purpose and able to deal with cyber-enabled international crimes, and we look forward to the proposed policy coming out. But we've also heard a lot about the challenges, a lot of which relate to the cross-border nature of these crimes and the digital evidence and managing that. We've been reminded about the importance of international human rights law and also conflicts of interest and managing those. Above all, cooperation networks are vital, and we've heard about the importance of partnerships and given many examples of those, and I'm sure there will be more to come as they'll need to be strengthened in order to tackle these kind of crimes. So we look forward to not only the policy itself, but the influence it will surely have on different national jurisdictions as they think about how to prosecute cyber-enabled crimes. It remains for me to thank you in the room for actively participating and for your questions, to thank those of you who joined us online, and to thank this wonderful panel. If you could join me in thanking the panel, please. And finally, thank you to Microsoft and the International Criminal Court for co-hosting this event, and I'll end it there. Thank you.